Just give it a minute for people to arrive. Good morning, everyone. My name is Enrique Zúñiga, and I am the Executive Director of the Massachusetts Peace Officer Standards and Training Commission, commonly referred to as the POST Commission. Welcome to this virtual public hearing. This concerns a set of regulations relative to the maintenance, reporting, and auditing of law enforcement records and information. This hearing is being recorded. Joining me remotely is General Counsel Randy Ravitz, and Jamie Ennis is here to provide technical assistance during these proceedings. We were expecting Commissioner Larry Calderoni to join us. If and when he joins, we'll just recognize him and bring him in as a panelist. But I will be presiding over this hearing today. The proposed regulations would, if adopted, become Chapter 12.00 of Title 555 of the Code of Massachusetts Regulations. They would establish requirements for law enforcement agencies and law enforcement officers to create and maintain certain records and to report certain information to the Commission. The regulations would also establish requirements and procedures concerning the auditing of law enforcement agencies and law enforcement officers by or on behalf of the Commission. Lastly, the proposed regulations enumerate ways in which the Commission may take disciplinary action against law enforcement agencies and law enforcement officers as a means of enforcing the obligations of these proposed regulations. At this hearing, we will receive oral comments concerning these proposed regulations from those of you who wish to offer them. For the past several weeks, we have invited members of the public to request that they be placed on the speaker list for this hearing and to submit written comments on the proposed regulations. If you did not previously ask to be placed on the list, you may do so today during this hearing by utilizing the Q&A function that is at the bottom of your screen. If you have called into by telephone, you can signal your interest in speaking by pressing *9 on your phone. After these introductory remarks, we will call on those who have expressed an interest in speaking. Please mute your audio when it is not your turn to speak. We will unmute you when it is your time to offer comments. We ask that when it is your turn to speak, you begin by telling us your name and then proceed to offer your comments. We appreciate if you limit your comments to approximately 5 minutes so that all who wish to be heard have an opportunity to speak. I see Commissioner Larry Calderoni has joined us. Welcome, Commissioner. We have just gotten started with my introductory remarks. After we have called the names of everybody in the list, we will invite comments from anyone else who may wish to speak but did not ask to do so previously. Please be aware that we are here to listen to your oral statements and will accept whatever written submissions you may wish to provide. But we will not be answering any questions or discussing any comments you may make at this hearing. If you need technical assistance, please inform Jamie Ennis, and we will be happy to offer any assistance. Again, the best mechanism to do so is by typing up a question or a comment at the Q&A function at the bottom of the screen. We will continue accepting any written comments on these proposed regulations that you or others may wish to submit until 5 p.m. today. Instruction for submitting written comments may be found at the Commission's website. If you are if you are interested on commenting on matters other than the proposed regulations that I have described, please send us a message with your full name and a summary of your comments, either by utilizing the Q&A function, as I mentioned earlier, or by sending an email to the address that is listed in the instructions for submitting written comments on the Commission website. With that, I believe we have a couple of people who previously signed in to offer comments. Jamie, can you remind me who that is? We'll start with the first person.
Sure, we have Chief Michael Bradley, who had signed up to speak, of the Mass Chiefs of Police. So I'm going to invite him in.
If he's in attendance, please bring him in and we'll recognize him. Good morning, Chief Bradley.
Good morning.
We can hear you. We don't see you, which is not necessary, but we can hear you if you want to start your comments. We're happy to hear them.
In just a moment, I'm going to see if I can get my camera rolling here. Okay, well, we'll start without the camera.
That's fine.
So good morning, Post Commissioners, Executive Director, staff and colleagues. My name is Michael Bradley, and I am the Executive Director for the Massachusetts Chiefs of Police Association. I am joined by our General Counsel, Attorney Eric Estepenis, on Zoom today. Thank you for this opportunity to provide comments on the proposed regulations 555 CMR 12.00, maintenance, reporting, and audits of law enforcement records and information. The Massachusetts Chiefs of Police Association, MCOPA, is a nonprofit corporation comprised of nearly 370 municipal and campus law enforcement executives from across the Commonwealth of Massachusetts. MCOPA was formed in 1887 to advance professional police services, promote enhanced administrative, technical, and operational police practices, foster cooperation in the exchange of information and experience among police leaders and police organizations of recognized professional and technical standing throughout the Commonwealth. MCOPA further champions the recruitment and training of qualified persons in the police profession and encourages all police personnel statewide to achieve and maintain the highest standard of ethics, integrity, community interaction, and professional conduct. As an association representing the interests of law enforcement executives throughout the entire Commonwealth, and the ability of those executives to maintain discipline, uphold high professional standards, and follow established human resource guidelines and statutes, MCOPA has a vested interest in the proposed regulations and the impact they will have on the law enforcement agencies throughout the state. Now, I'd like to turn it over to Attorney Eric Estepenis to walk us through our comments and concerns regarding these regulations. Attorney Estepenis. If we could switch over to his Zoom account.
Yes, Jamie will bring him in a minute.
Thank you.
We can see that you're coming in, Mr. Estepenis. We cannot see you or hear you if you wanna.
Good morning. Can you hear me?
We can hear you.
Okay. For some reason I can't activate my camera, so I don't know if there's something.
Is there something with the security settings, Jamie? Do you know? It'd be nice to see them, but yeah, again, it's not necessary.
Okay, there we go. I think I'm all set now.
Okay, maybe the settings change. They move around.
I was just brought in as a panelist, so I don't. I think
That's what did it. Okay.
I appreciate it. So Executive Director Zuniga, General Counsel Ravitz, Commissioner Calderon, good morning. My name is Eric Atstepenis. I serve as the General Counsel for the Massachusetts Chiefs of Police Association. In preparing these comments and the written testimony to be submitted shortly, we consulted with agencies across the entire Commonwealth, from the largest, like Boston Police Department, to the smallest. These 14 points represent our collective concerns regarding these proposed regulations. First, the proposed regulations impose extensive record keeping and reporting requirements that will necessitate significant additional resources, including personnel and technology. Many law enforcement agencies, especially the smaller ones, may lack the necessary funding and infrastructure to comply with these mandates. We urge the Commission to consider the financial and logistical impacts on law enforcement agencies. Second, the increased reporting and auditing requirements raise substantial concerns regarding privacy and security of sensitive law enforcement records. It is essential to ensure that any data shared or audited is adequately protected against unauthorized access and breaches. We recommend the inclusion of robust data privacy and security measures in the regulations to safeguard that sensitive information. Third, the proposed regulations could impose a considerable administrative burden on law enforcement agencies. The extensive documentation, reporting, auditing requirements could divert from critical resources from essential policing activities, potentially affecting public safety and operational efficiency. We therefore recommend a more balanced approach that minimizes administrative burdens while achieving the intended objectives of transparency and accountability. Fourth, the draft regulations refer to creating certain records and placing them into an officer's personnel file. Specifically, Section 12.041 provides that for each officer that an agency employs, the agency shall create and maintain the following records. Now, while the phrase "and if practicable" attempts to mitigate this requirement, there remains considerable confusion about what should and should not be placed in an employee's personnel file. Now, including all of the records identified in the draft regulations in an employee's personnel file could actually violate federal and state law and even best practices. So our written testimony actually lists specific items that either must not be or should not be in an employee's personnel file. And it could also conflict with existing policies, procedures, and collective bargaining agreements. For instance, some agreements stipulate that certain disciplinary documentation must be removed from a personnel file after a specified date, although not destroyed. This removal is meant to exclude the consideration of those instances from future personnel actions and employment decisions. Fifth, the draft regulations suggest that they will supersede the existing Massachusetts records retention schedules. By requiring an agency to create and maintain specific records without specifying a retention period, it necessarily implies that agencies may no longer lawfully dispose of records pursuant to our public records law and existing records retention schedules. Some documentation may have actually already been lawfully destroyed, and requiring agencies to recreate those records is impractical and impossible. The regulations should state explicitly that they do not supersede existing records retention schedules or require the recreation of previously lawfully destroyed records. Sixth, Section 12.51I requires agencies to report any change in an officer's work status, including on leave status. It's unclear whether this includes vacation, sick days, bereavement days, etc., so clarification is needed to avoid misinterpretation. Seventh, Section 12.071A requires officers to maintain all records enumerated elsewhere that come into their possession. This requirement is vague and burdensome, and clarification is again needed regarding its scope and intent. Eighth, Section 12.071D2 requires officers to ensure accuracy in all representations made to any, quote, body or person of authority, end quote. This term is vague and needs clarification. Does it refer only to statements made in an official capacity as an officer? Ninth, Section 12.083 permits the Commission to retain non-employees to conduct audits. Clarification is needed on why non-employees would be used and what qualifications they must possess to ensure the integrity and confidentiality of audits. 10th, we have Section 12.091A2M, which refers to generally accepted law enforcement standards without defining them. If the Commission is going to audit compliance, these standards must be clearly defined. That flows into Section 12.091A3 as well, which lists subjective factors such as adequacy, completeness, and appropriateness for evaluating agencies. Again, this is akin to conducting a performance evaluation of an employee without first establishing clear criteria and metrics. Clear objective standards should be established to guide these evaluations. Now, section 12.091A4E includes the audit of internal and external communications, including interactions with complainants, victims, witnesses. Disclosure of ongoing investigation communications could jeopardize those investigations. So the regulations should specify what qualifications for auditors there are to ensure confidentiality of reviewed records, including adherence to any DCGIS requirements. Overall, we're concerned that the Post Commission is seeking to establish audit procedures before clearly defining the requisite criteria that departments will be evaluated on. This approach is akin to putting the cart before the horse. Before auditing other agencies, Post should focus on clearly establishing and communicating the standards and criteria by which departments will be evaluated and to provide the departments with any necessary training. Moreover, while the Commission has the authority to conduct these audits, it's imperative to consider whether it is necessary and appropriate at this moment. Implementing audits without a solid foundation of established criteria can lead to confusion and inconsistent evaluations. It's crucial for Post to ensure its own procedures and standards are fully developed and transparent before auditing requirements are imposed on law enforcement agencies. 11th, section 12.042 requires law enforcement agencies to create and maintain records related to constables in their jurisdiction. Constables are elected officials, do not work for the law enforcement agency, so these records should be maintained by the municipality, not the police department. 12th, section 12.081 permits the Post Commission to initiate an audit at any time. Typically, audits from outside oversight agencies, like the Department of Labor, for instance, are triggered by a complaint or other notice of noncompliance. Allowing the Commission to initiate audits without such triggers seems overreaching and could lead to unnecessary disruptions. 13th, section 12.10(1) permits the Post Commission to require an officer to provide a statement regarding records under the pains and penalties of perjury. Where officers are required to provide a statement and where their continued employment is directly connected to their certification from Post, has Post considered the impact of existing jurisprudence on the issue of compelled interviews? For instance, under the Weingarten decision, officers who are in a union are to be afforded with the opportunity to have a union representative join them when subjected to investigatory interviews. Furthermore, employees may have additional rights to transactional immunity under the Carney decision when compelled to make a statement that could result in criminal charges. Again, while Post is not the employer, the officer's employment is inextricably interwoven with their continued certification, which is controlled by Post. Lastly, section 12.12(2) permits the Post Commission to levy and collect assessments, fees, fines, and impose penalties and sanctions against an agency or officer, but does not address what kinds of assessments, fines, and fees are permitted. As written, it would provide Post with unbridled discretion to assess those sanctions. This should be limited and specified. Now, in conclusion, while we support the efforts to enhance the integrity and accountability of law enforcement through the improved record keeping and oversight, we believe that the proposed regulations require significant revisions to address the concerns that we just previously outlined. We respectfully request the Commission to consider our recommendations and to work collaboratively with law enforcement agencies and our own association to develop regulations that are clear, feasible, and effective. Thank you very much for your attention to these important matters. We look forward to working with the Commission to achieve our shared goal of promoting professional and accountable law enforcement here in Massachusetts. Thank you very much.
Thank you, Mr. Azupenas. We appreciate very much your insight, your comments, and your perspective. Now we can see Commissioner Calderon. Welcome again, Commissioner Calderoni. I think, Jamie, we figured out that we need to bring somebody who wishes to speak as a panelist so that we can see them and hear them without any issues. I think that does the list of people who signed up in advance. Is that correct?
Correct. And we have Dennis Galvin in the Q&A asked to speak, so I'll bring him in as a panelist next.
Very good. Mr. Galvin, we'll give us a moment and we'll bring you in as a panelist and recognize you in a minute.
Hello.
Good morning, Mr. Galvin. We can see you and hear you.
Good morning, Mr. Zuniga. How are you this morning?
Good, good. Thank you. Nice to see you. Welcome.
Good morning, members of the post-commission staff and board members and Mr. Calderon. Thank you very much for the opportunity for us to address this issue. The Massachusetts Association of Professional Law Enforcement is an organization of retired, current, and former police officers, as well as criminal justice educators. We're a 501c3 corporation, and our purpose is to address and improve the effectiveness and the public perception of policing within the Commonwealth. So we appreciate this opportunity to address you. Our membership has had a chance to review the drafts, and we have approximately just basically 3 comments to make on them. The first one with regard to the attorney from Macopa has talked about the general personnel files. Our focus on the personnel file would be in section 1204, section 1B3, where it's we would ask you to consider exempting letters of counseling from those files. Letters of counseling are informal, basically informal notes that are done from supervisors to subordinates addressing simple matters. For example, making sure that the cruiser has gas in it, making sure that equipment is maintained, things like that. And these are used generally to allow for evaluations of officers within a certain evaluation period. And after that evaluation, they support the evaluation and they're gone. What we're concerned about is by elevating everything to that file, that you're going to now create a chilling effect, which will sort of, which could cause a problem for supervisors as far as their unwillingness to document issues because they're afraid they're going to wind up in the file. So that's the first issue that we have. The second one is that you talk about the complaints, and I think we have a larger there's a little bit larger discussion, but I think it pertains to this, is that the word complaint needs to be basically described in greater detail. We recommend that you utilize the standard idea of complaints, that they're categorized into sections of sustained, not sustained, basically exonerated, and unfounded, the four categories. And the purpose behind this is to provide for a more accurate evaluation of what complaints actually are. The word complaint alone is a very loaded question. It has a couple of drawbacks. Number one, if you just count complaints with nothing else, and I've seen this done in a couple of prior hearings, not involving you folks, but involving adjudications on certifications, what happens is it's a violation of procedural justice. The complaints, if they're going to be considered, should have a foundation and should be backed, and it should not be simply on the basis of the fact that a complaint was filed. The other problem with that is it will contribute to what is called depolicing. Officers will draw back from engagement simply because of the fear of having those complaints issued. And we also think that certain complaints, such as those that are unfounded and unsustained, should be expunged after a period of time. Not only that, but as the Macopa representative mentioned, you're creating a very heavily burdened documentation system. You want to get some of this stuff out. Experience is long taught departments that unfounded and not sustained complaints should be dropped after a certain period of time. We have a concern about section D11, and we want to raise this to your attention, and it has to do with prosecutorial evaluations and terminations. Our examination of that process at this point indicates that these determinations are not done with a scrupulous attention to due process. They are evaluations that are based upon a lot of times subjective information, incomplete information held by the district attorneys. Our recommendation to post is that if there's an issue about a police officer's credibility in testifying in court, that should be a subject for the post commission to investigate and should render a finding one way or the other. And I know it's a serious finding; it could lead to decertification. But the idea of carrying these determinations, which are not really vetted well, we think is problematic for police officers and is not accurate. Finally, we would raise a concern about section 1208, section 4, where it seems like there's an unrestrained authority to delegate your authority to other agencies once you open the audit. we believe you should retain your authority based on our experience with Massachusetts government. You should guard your authority. You should maintain it. Now, if there's a pretext that generates through an audit in which another agency has correct jurisdiction over or has jurisdiction over, there's no issue with referring it to it. But to make it an open-ended comment where you're just going to open it up to another agency, we urge you not to do that. Not only for your own credibility, but for the credibility of the process itself. And the last part is Section 12, Section 1, which has to do with the sanctions. And I heard the discussions on the sanctions before, but and that there was a distinction made between a police officer and an agency. But in reality, somebody in the police agency is responsible for those records. And if there's a sanction leveled against the agency, it will be automatically leveled against anybody involved in the record keeping. We think that you should inject a standard of willful or negligence in there so that, that there's at least a requirement of a showing that you tried to make several contacts, were unresponsive, or somebody just decided not to participate. I mean, it doesn't have to rise to the level of beyond reasonable doubt, but just qualify it so that somebody caught up in the normal bureaucratic tedium and stress just doesn't become the subject of a disciplinary action, because that can happen, as the folks at Macopa just realized. There will be a lot of burdens, and some people are going to have to handle this. So those are our comments. We thank you very, very much. We appreciate the opportunity, Pine. And if there's anything else that we can do, just let us know. Thank you.
Thank you, Mr. Galvin. We appreciate very much your comments, your perspective, and your experience. Thanks for participating. Okay, Jamie, I think there's a question about written materials available regarding the specifics of today's meeting. Let me mention that those materials were and have been listed on our website by virtue of the calendar that people signed in. That should be available there. There was a link that I remember where we say request for public comment. By clicking on that link, people could find and be able to download the regulations. Those are, again, 555 CMR 12.00, auditing and maintenance of records. Maintenance, reporting, and audits of law enforcement records and information. Okay, I see a comment. I see a comment that I will take at this point. It says, will we be able to access the written comments provided here? They're specifically thinking about Macopa, but let me speak to all the comments received. Our practice in the past, which we will continue to do, is to bring a full set of comments received until 5 o'clock today to the next commission meeting, at which point we expect and anticipate to, at a minimum, provide an overview of those comments to the commissioners, even though some of them are in attendance and this meeting is being recorded. That meeting is scheduled for August 15, if I'm not mistaken. That's a Thursday, 8:30 a.m. So we will make all of the comments received until 5 o'clock today available at that time. And at that time, we will also be providing the commissioners with an overview of these comments. With that, I think we've answered the questions posted in the Q&A section. We have also addressed those people that signed up in advance to provide oral testimony. At this point, I will ask if there is anyone in attendance who would like to provide oral testimony this morning. If there is, please signify your intention to do so by indicating or writing your intention in the Q&A function, the question and answer function that is at the bottom of your screen, for us to be able to recognize you and bring you in as a panelist to provide comments. Commissioner Calderon wants to make a comment.
Thank you, Mr. Director, and my apologies for being a little tardy here as I was a little late running on another Zoom as well. I'd just like to make a comment for consideration by the commission, backing up a letter that was submitted by the Mass Coalition of Police. That one of the points that they make inside their document and their suggestion is related to 12.07, the maintenance and the reporting of information. It appears as though it's an abundance of information that we're putting the onus or to possibly put the onus on the officer themselves. That's a tremendous amount of information, paperwork, etc., that we're going to put the burden on the officer of acquiring and keeping and maintaining. I don't know where that would be done. Is that expected to be done at home? I can tell you unequivocally that departments are not going to give each and every officer file cabinet space to keep the abundance of paperwork that's coming forth. So backing up what the Mass Coalition Police has to say and other police groups that have contacted me wishing that I would bring this to the forefront is I respectfully request that we take a look at the onus that we're placing on the officer. If there's a way that maybe as a commissioner, I fully understand what we're doing with the department, but I think that that's probably something that we should take the officer's responsibility out of and let the department maintain those folders and those files. To create such a burden for the officer themselves, we're second guessing that, sir.
Thank you. We'll make sure we address that and all other comments relative to that. As I may have mentioned, at a minimum, we expect that on the August 15 meeting to provide a summary of the comments, including in the packet the full comments that we get as part of this process. If time permits, we will be eager to have our own perspective, clarification or whatnot at that meeting. Are there, once again, are there anybody in attendance who would like to provide oral testimony on the proposed regulations? Those are 555 CMR 12.00. That's the maintenance, reporting, and audits of law enforcement records. If you're interested in providing oral testimony this morning, please signify that intention by typing up your name or your desire to do so at the Q&A function, which is at the bottom of this screen. Or if you are attending by phone, although I don't think there's anybody attending by phone, but in case there is, you would please signify that by dialing *9 for us to be able to recognize you. Okay, Jamie, I don't see any other questions or anybody raising their hand. Or anybody who has signed up to speak, is that correct?
Yes, it appears so, correct.
Let me mention once again that I'm presiding over a public hearing of the Massachusetts Peace Officer Standards and Training Commission regarding the proposed regulations 555 CMR 12.00, and that is the maintenance, reporting, and audits of law enforcement records and information. We are taking public comment, oral testimony this morning. We will be here until 12 o'clock. We're scheduled to be there until 12 noon. And we have notified the public that we are accepting comments until 5 o'clock this morning. They can be submitted, 5 o'clock this afternoon. They can be submitted by following the instructions in our website, to the mailbox in our website. Once again, we are conducting a public hearing on the proposed regulations of the Post Commission. Those are 555 CMR 12.00. That's the maintenance, reporting, and audits of law enforcement records and information. If there is anybody in attendance who wishes to provide oral testimony, please do so. Indicate that intention, rather, by clicking on the Q&A function at the bottom of your screen so that we can identify and bring you in as a panelist so that you could provide oral testimony. Okay, seeing that there's no comments or anybody in attendance wishing to provide oral testimony at this time, I'm going to suggest that we temporarily break or suspend this hearing, and we come back later on to see if there's other people in attendance who may want to provide oral testimony. I'm going to suggest that we come back at 11:30. Randy, what do you think about that? Once again, before we take a break, if there's no one else who would like to speak at this point. And if you wish to do so, please let us know by raising your hand or submitting any questions to the Q&A function at the bottom. There will still be an opportunity to provide additional testimony. This hearing is not being concluded yet. Seeing that there's nobody who wants to provide testimony at this time, I'm going to suspend this hearing momentarily, and we will come back at 11:30. Commissioner Calderon has a question or comment?
Yes, thank you, Mr. Director. Just a quick reminder, I have an 11, I won't be able to come back, but I just wanted to say thank you.
Yeah, thank you for your attendance and comments, sir. We will be here until 12 o'clock as scheduled, or longer if people all of a sudden, attend and provide two other comments. But seeing that there's nobody at this time, we will again suspend momentarily. We'll stop recording, and Jamie will keep this link live as is our practice, so that anybody can join at any time. And we'll share our screen to say that this proceeding is temporarily suspended and that we will come back at 11:30 a.m. This morning in about 45 minutes. With that, thank you, everybody. Thank you for those who have been attending, who attended and provided comments. Thank you for those attending. We are not adjourning. We are temporarily taking a break, and we'll come back at 11:30. Good morning again. We are back from our recess this morning. Once again, I'm Enrique Zuniga, and I am the Executive Director at POST, the Massachusetts Peace Officer Standards and Training Commission. This is a public hearing to hear oral testimony of regarding the proposed regulations. Those are 555 CMR 12.00. Those are the maintenance, reporting, and audits of law enforcement records and information. We have some people in attendance. We have heard oral testimony this morning. Thank you for those that submitted written comments as well. We are still accepting oral testimony. If there's anybody in attendance who would like to offer any oral comments, please indicate your intention to do so by either raising your hand or typing up anything on the Q&A function at the bottom of your screen. Good morning again, and once again, this is a public hearing of the Post Commission regarding the proposed regulations 555 CMR 12.00 maintenance, reporting, and audits of law enforcement records and information. We started this public hearing this morning at 10 a.m. We heard some thoughtful comments. Thank you to all of those who took the time to read the regulations and provide comments. We have also been accepting oral testimony this morning, and we'll be here until 12 o'clock. The proposed regulations have been posted to our website for the last month, at least. You can find them in the calendar of events for this proceeding. There's a short description of the regulations and a link to the full regulations in our website. We are still accepting oral testimony this morning. If you are interested in providing oral comments, please signify your intention by raising your hand or typing up anything or your intention to do so in the Q&A function at the bottom of your screen. If you're attending by telephone, you can also signify your intention to provide oral comments by dialing *9. We will recognize you if that's the case and invite you to provide oral testimony. I will mention as well that, as I've mentioned before, throughout this morning, that we are accepting written testimony until 5 o'clock this afternoon. The way to do so, the way to provide testimony is indicated in our website. You can also click on the link in our website with our general mailbox, post C-comments at mass.gov, and we'll ensure that the appropriate people receive those written testimony. Is there anyone else in the audience, on those in attendance? We can see that there's still people in attendance. Thank you for joining and staying with us. Is there anyone at this time that would like to provide oral testimony? Okay, seeing none, let me suggest that we once again take a break and resume these proceedings right before the scheduled closing time, that is 12 o'clock. We'll resume at 11:55, just in case there's anyone at that time that makes it into this hearing and wishes to provide written testimony. With that, Jamie, if we could just share the screen, pause the recording. We will be back at 11:55 to see if there's anyone else who would like to provide comments, and if not, to close the hearing. Thank you. Morning again. Good morning again. We are still conducting the public hearing of the Post Commission regarding the proposed regulations 555 CMR 12.00 for the maintenance, reporting, and audits of law enforcement records and information. We have been taking oral testimony this morning. That has included a couple of breaks. As I come back from breaks, I once again look for anybody who might still be in attendance and ask if they are interested in submitting, in providing oral comments or oral testimony this morning. We were scheduled to be here until 12 noon. I see that attendance has dwindled a little bit, but there is still some people in attendance. Anyone at this point who would like to offer oral comments, please signify your intention by raising your hand or typing up anything in the Q&A function at the bottom of your screen. Okay, seeing none, let me thank you on behalf of the Post Commission. I would like to thank all of you who have attended, participated, and provided any kind of written or oral testimony regarding these regulations. This participation in the regulation promulgation process is critical, and we are thankful for that participation. The public comment period is, of course, an integral part of the establishment of effective regulations, and an important part of our process. Following the conclusion of this hearing, which I intend to close in a few minutes, and the period for submitting written comments, which is still 5 o'clock this afternoon, we will carefully consider all the oral and written comments that we have received and have been offered into the draft regulations. We anticipate that the proposed regulations will be discussed again at one or more duly noticed public meetings of the Commission. As I mentioned earlier this morning, the next Commission meeting we have tentatively scheduled for August 15, that's Thursday at 8:30 a.m. Please look for the notifications about the agenda that we post, as we are required to do with 48 hours in advance. If the Commission decides to adopt the regulations at that or a subsequent meeting, they will be published in the Massachusetts Register. At that point, those regulations will become effective. Once again, thank you for participating. Thank you for all the thoughtful comments. Please visit our website. You can still provide written testimony before 5 o'clock this afternoon. The regulations are posted to our website. They have been posted there for a month. Thank you to all of those who participated. Thank you to all of those who attended. At this point, I'm going to close the hearing and stop the recording.